Well, I think my line of questioning will be quite different, Mr. Walsworth. As you stated when you came before the members who were up for confirmation, the number one purpose of a board is to protect the public, correct?
Yes, sir.
Yes.
Let's talk about Mr. Veters. Are y'all familiar with Mr. Veters?
Yes, sir.
How many charges of sexual assault is he facing right now? 9. Is he a physical therapist?
Yes, sir.
When did y'all first start receiving complaints about Mr. Veters?
We received a complaint about Mr. Veters in 2016. Was it?
So are you talking about the licensing board? Yeah, so Ms. Harris isn't familiar with all the complaints received by the board. So prior to my coming onto the board, there was a complaint received on
and what happened with that complaint?
So I was not on that investigation. I did not work there at the time. But at that time, and Ms. Harris may be able to speak somewhat to this because she's a physical therapist. But the way that I understand it is that a complaint was received by the board and an investigation was conducted. Medical records were reviewed. Physical therapy records were reviewed. The complainant was interviewed. The licensee was interviewed. And the first determination that needed to be made was this a physical therapy technique? Because the executive director and the attorney are not physical therapists. So the physical therapist on that committee reviewed the records and determined that it was a legitimate physical therapy technique. The next question becomes, was the technique appropriate for the condition? And it was determined that when everything was reviewed, it was determined that for that condition, the technique would be appropriate. And then finally, the question would be, was it performed appropriately? And there was some concern. There was some concern that this individual should have educated the patient more, should have offered to have somebody in the room, and should have done some other things. So a letter of concern was written, and it was documented that the investigation was conducted, this was found, and that the licensee was educated to correct this action. And should anything come up in the future about this, this would establish a pattern and determine whether or not this was an isolated incident or whether this had occurred again. And so whenever a complaint came upon Mr. Veters, we reviewed the letter of concern and we used that in this complaint and Ms. Harris was on that complaint that you're referring to, I believe.
Couple of things. Number one, I think it's impossible to deny that definitely there was a swing and a miss on Mr. Jeters. Would y'all consider that probably appropriate? Because the fact that upon investigation, let me be very clear, and I'm going to be as candid as I can be. Mr. Walsworth and I were both people that when the physical therapist of Louisiana were seeking to have direct interaction with patients without doctor's recommendations, we were part of the group of people that fought the orthopedist so that patients didn't have to go and get prescriptions to see physical therapists and receive physical therapy. I take allegations of sexual assault very, very, very seriously.
Yes, sir.
Very seriously. And the thing is that we, as a legislature, give boards grace in that we are convinced and believe that their job is to protect the public. I have some sexual assault victims here today, and you know that because your executive director has already been talking to them and trying to find out who's who. What concerns me, is if you thoroughly investigated someone's case, how do you not know who is who in the audience?
Okay.
Put a pin in that for a second. We give boards authority and autonomy because your primary goal is protecting the public. I'm going to invite these victims up momentarily, either during this confirmation or during the bill, I haven't decided which yet, to explain what they went through with your board and how their experience was. Your job as a board is not to look out for physical therapists, is to look out for patients. We occasionally, and we've had this fight before, we have boards that we believe are overzealous at times in their prosecution. But I will tell you, I will take an overzealous board over a board that is not doing their job any day of the week. Because an overzealous board, we can correct through legislative action. A board that's not doing their job, that's a whole different problem. But like I said, I will hold the rest of my comments, Mr. Vice Chairman. I think that it would be appropriate to bring these victims up during the bill because I think that there's some issues in the bill that could correct this. I do want their testimony on the record, but I will tell you this much. I have grave concerns about confirming people on a board if I don't feel like the board's doing their job. I will tell you, I've worked with behavioral analysts. I've worked with boards like yours to make sure that you are not indentured servants under medical boards that tell you what to do. But today I tell you, and I'm going to hear from these victims in a second about what their experience was with your board. Because I will tell you, what really, really makes me angry is that when a sexual assault victim has the courage to contact a board and tell them they have a problem, and they are not taken seriously. That I will not stand. And if you thought that because I'm term limited, this wouldn't be a problem, I will tell you the chair of this board is 10 times worse than me. And when they tell you their experience, members who wish to be on this board, if you do not correct this action, there won't be a physical therapy board. Far as I'm concerned, you'll be a subsidy of the orthopedist board. And don't think for a second we don't do that, because we do. And if you won't do your job, we'll put you under a board that does. Like I said, I'll hold the rest of my comments till the bill comes up, because I think that's more appropriate than confirmation, because obviously the individuals here for confirmation, you're new to the board. Many of these things obviously predate you, and it's not fair to put that on you, but I will hold the rest of my comments till the bill comes up. Thank you.
Yes. Good morning. My name is Morgan Lomond. I'm an attorney that works for Sexual Trauma Awareness and Response. It's a sexual assault organization that serves the Central and South East Louisiana areas. And I wrote a letter to the board chair, which you all should have a copy of that, in which we were asking for oversight of the physical therapy board, because my client, who will be able to tell you more about her experience, was essentially, once she was not wanting to provide certain information that they were requesting outside the scope of their investigation, she was met with basically, in our view, hostility. And there was the attorney for the physical therapy board requested that I provide a detailed explanation of why I was representing her in general and what, to the extent of the representation. And in my view, he was basically asking me to reveal attorney-client privilege. And so the letter and the news article that's referenced is, you should all have a copy of that. I'm happy to answer any questions, but at this point, I'd like to just defer to my client.
Okay, welcome. If you could introduce yourself. Yeah.
My name is Casey Walker. Thank you
Welcome.
guys for having me today.
Welcome.
In June of 2017, I was sexually assaulted by Philippe Vieters. With the exception of telling only a handful of trusted people, I suffered in silence for the next year and a half. This past January, I discovered that he, Mr. Vieters, was currently suspended from practice for sexually assaulting another victim after me in the summer of 2018. It was at this time that I felt the courage to speak out and subsequently contacted the Physical Therapy Board. First, I'd like to state that I was not aware that the Physical Therapy Board even existed until January of this year. Had I known that of its existence, I may have contacted them sooner, and I feel like the public should be better informed of the proper avenues in which to file complaints against medical professionals. It took a lot of courage for me to speak out about the assault that I endured. Unfortunately, after sharing my story with the board in late January, I regret ever speaking to them in the first place. Not only have they not provided me with any information regarding my complaint, but they have also belittled me, were dismissive of me, and acted as though my complaint was a burden to them. In fact, in fact, in a February email from the board's attorney to the executive director, he called my legal representation, quote, unnecessary and burdensome, and he used that as a reason to say, quote, I am not inclined to proceed further in regards to Ms. Walker's complaint, end quote. I find it offensive that the board demanded to know why I had representation, while no one would ever question why the perpetrator had an attorney. I was looking for support and guidance in an extremely personal and overwhelming process. At the Lafayette meeting, hold on, sorry, I'm gonna scroll, okay. At the Lafayette meeting I had with the board, I provided them with a written statement, medical records, and phone records that were relevant to the assault. Additionally, I physically demonstrated to them how he sexually assaulted me. Sorry.
Take your time. As a fellow sexual assault victim, I understand, and you take your time.
In turn, I was met with comments such as, and I'm paraphrasing, you have a lot of detail in your statement, which is odd. And, well, he's not practicing for the next 9 months, so that should make you happy. It's comments like these that keep women, including myself, from ever reporting their assaults. After the board meeting, I felt trivialized, diminished, and re-victimized. I couldn't believe that this was the board that I was supposed to investigate, my claim. In early February, about a week after the meeting with the board, the perpetrator, Mr. Veters, was arrested on 2 felony counts of forcible sexual battery. One of the counts was in relation to my case. He has since been arrested 3 times and is currently facing 9 sexual assault charges by multiple victims. After his arrest, I emailed the board asking for an update on my complaint and to address what, if anything, would happen to him since he had been arrested. My email was met with hostility and language that I found abusive. My assault was called by Miss Charlotte Martin, quote, the incident, and the respondent requested that I provide her with my medical records, my mental health medical records. According to the board, they needed my mental health records to prove that I wasn't seeking attention because the media interest in this case, when in fact, I had come forward before there was ever any media interest in the case. What is the purpose of this board if there's no oversight of their investigations? How are sexual assault victims like myself supposed to trust the board if we are only met with hostility and reprehensible attitudes? What does it take for the board to take action against one of their licensees? If 9 sexual assault charges and multiple victims aren't enough for immediate action, then what is? What is? Is he going to be able to practice again in 4 months when his probationary period is over? Are his patients going to be informed of the charges against him? And are the previous complaints brought before the board, are people going to be notified of those complaints? Since the board refuses to address these questions, I'm hoping today that I can get some answers. I'd like to know what, if anything, has been done by the board in my case regarding my complaint. Hold on. Will my complaint be properly investigated? And moving forward, what oversight your committee can provide to ensure that all sexual assault complaints brought before the Physical Therapy Board are properly and thoroughly investigated? Thank you.
Thank you very much, and I want to just thank you for your courage, and the certainly we appreciate your being here. I was participating in a side note, just participating in the interim on a committee that was studying and trying to make recommendations to the legislature and the state on how to come up with uniform policies for not just the state government departments in the legislature, but also agencies and boards like this one, right? And so I can tell you right now, clearly, based on your testimony, which I believe, because there's no reason for any woman to put themselves, or man, to put themselves through this. Like, who does that, right?
Right.
To just disparage someone's character, right? And so this has been a elongated process, painful process for you. I hope that we can come to some resolution soon. Most importantly, for your mental and physical health. Because I too, as I mentioned, am a sexual assault victim, and it took years for me to tell more people. I too only told a few people early on, but then only in recent years that I figure out a way to take action and have that person who only in a short time ago is having to pay for, and in a way that I'm not going to describe right now, the ramifications associated with their behavior against me, because it's a prominent person, and sometimes people think that they're invincible, right? And this board, obviously, in the profession that Mr. Veters has, along with the investigator that serves to fulfill the duties and responsibilities of the board, need to both be held accountable to how these processes work, with due process, certainly for the people accused, but also with the sensitivity needed for the victim. Right? And so I apologize for what has transpired, but we can only move forward, and we intend to. So with that, Senator Morrell, I don't know if you...
Thank you so much for testifying today. It's only with people with courage like yourself coming here and putting this on the record that we will have the ability to make lasting, immediate change. And I will tell you, there will be outcomes and repercussions out of this meeting that will be swift and that will immediately begin to address this issue.
Thank you.
I know we have another person here to testify. I'd like to get to her as quickly as possible.
Thank you. Yes, ma'am.
Good morning. My name is Lori Jennings. I was assaulted by Mr. Veters on June 7th in 2018. I immediately reported it to the PT board only because I have good friends who are physical therapists, and they were able to guide me in the hours after my assault. Just like the other victim here, I did not know that there was a PT board, and I did not know that there was a system to file complaints, which maybe is the reason why there's only 30 complaints a year. You are in such a state of shock after a sexual assault. Only someone who has experienced severe trauma can really understand what I'm talking about. I submitted the complaint online, even though it felt strange to write the intimate details of such a horrific encounter on a form that I had no idea where it was going to and who was going to read it. If it hadn't been for my well-educated PT friends, A, I would have never known this online complaint existed, like I mentioned, and B, I would not have been assured that I could trust it. At first, my dealings with the board were fine. I gave them the facts and details that I could remember. They reviewed my complaint, then they met with the complainant, Mr. Veters, and his attorney, and then they wanted to meet with me face-to-face. All of it seemed fine. Then I learned from Ms. Martin, the director, that she and their investigative board member, Ms. Harris, were continuing to investigate my complaint against the advice of their attorney, Mr. George Papale. To this day, I would like to know why Mr. Papale did not want the board to investigate my complaint, knowing Mr. Veters had a similar complaint and had been put on notice before. If Miss Martin and Miss Harris had actually taken their attorney's advice, we wouldn't be here today. And this complainant, Mr. Veters, would still be practicing and assaulting women. That is a very scary thought. How many times has this board actually taken their attorney's advice and not investigated a sexual assault claim? For my face-to-face meeting with the PT board, my sister and I met with Mr. Papale, their attorney, Stephanie Boudreau, Ms. Martin's assistant, and Julie Harris, the investigative board member. Julie Harris was on Skype as she was in the Shreveport office and wasn't able to be there present in the Lafayette office. One thing from this meeting that still haunts me to this day is that I was asked to show them exactly where he touched me. I still do not understand why I was asked to pull my pants and underwear down in a boardroom to relive this horrific experience all over again and to be so humiliated. I feel like if these individuals had any experience and training in dealing with sexual assault victims, they would have never asked me to do this. I still relive this and wonder why I even complied with their request. I felt this request completely re-victimized me, was insensitive, humiliating, and 100% unnecessary. What if I had said no? Would they have just dismissed me? I'm not sure. During this meeting, Mr. Papale became enraged a few times when my sister and I would ask questions if what Mr. Veters did to me was considered proper and standard care. He became enraged. Even though we both knew the answer, we asked. We wanted him to answer it. At one point, I told him I knew why he was being so angry. Because I told him I knew he did not even want to investigate my complaint. He told me this was a serious allegation, and I replied with, it was not an allegation, it was a fact, and I told him Ms. Martin had told me that. I do not believe he had another comment after I told him that. The way I was treated after such a traumatic event was so horrific. Looking back, I honestly do not understand how I kept going, and this went on for 7 long months. I now know why this predator was allowed to continue to do this to women for so many years. After this meeting, all the communication with the board was via email. I would say I felt the board began treating me very differently. I do understand their job is to be unbiased and gather all of the facts, but I do not think they need to humiliate, threaten, or scare any assault victims. Their job should be to gather the facts and not make the victim feel like we are the criminals. It seems they lack any training in dealing with actual sexual assault victims, and that is extremely sad because the trauma from the actual assault is enough pain for the victim to deal with. At some point, I finally received notification they would need me for a hearing. After months of meetings, emails, questionings, and phone calls, I finally hired an attorney because I had come to the realization no one cared and no one could be trusted. During the months following my assault, I learned this man had assaulted others, and I just honestly could not walk away and let this continue. I thought I could continue the process alone, but realized everyone was just trying to wear me down and was hoping I would just go away. When I found out about the board hearing, I let my attorney know, and she told the board to communicate only with her from that point on. Well, Mr. Papale, the board's attorney, sent my attorney a letter and basically said the board did not have to comply with her request in a very insulting manner. And that I have in an email. I was shocked and horrified at his letter. I again felt like he was treating me like I was the criminal. We actually ignored Mr. Papale's letter, and the board did communicate with my lawyer as we requested, even though he cited various reasons why he legally was not required to do so. Regarding the hearing that was scheduled for December, Mr. Papale told my lawyer he did not want her present when he prepped me for the hearing, nor did he want her attending the actual hearing. He claimed he had been doing this for many years and he knew what he was doing. He told her if she showed up for the hearing, it would appear I was just after money. I consulted with my family and friends and told my lawyer she could tell him I'm very sorry, but she will be with me for the prep and the hearing. By this point, I had been beaten down by every person who should be protecting me, so I trusted no one. I did not care what anyone thought. All I cared about was stopping him from hurting another patient and having that person endure what I had gone through and still suffer until this day. It was interesting that after all of this, I never did meet with Mr. Papale for this prep, nor did they have the hearing. Amazingly, Mr. Veters signed a consent order and was suspended without the hearing ever taking place. Why did Mr. Papale not want my complaint investigated? How many sexual assault complaints are actually submitted to the board? And of those, how many are actually investigated? Why was Mr. Veters only put on notice for the first complaint and basically allowed to assault me? Why did the board allow him to continue practicing for months while they investigated my complaint, knowing this wasn't his first time, and their investigation took 7 months? At what point are they liable for the victims who came after me? How many women were victimized after my complaint during their 7-month investigation? Currently, he is suspended. However, once that suspension is lifted, he is allowed to continue to operate as a PT in the state of Louisiana under a probationary status where he is not allowed to be in the room with a female alone during that time. My question is, who will monitor that? This man has been arrested 3 times and is now facing 9 criminal charges. He was given a slap on the wrist in 2012, and in my opinion, this consent order is not enough, knowing he could operate under this probationary status in just a few short months. This scares me and should scare everyone in the room. The PT board should be monitoring the PTs. Well, who is monitoring this board? Who are they really serving? Because they are not protecting and educated the PT patients in our state. This board is failing all of us.
Thank you very much. And I, too, thank you for your courage and for being here and sharing your story. Can you tell me, and I hate to revisit this, but you presented it in your testimony, when you were at a board meeting in Lafayette, you said, and you were asked to pull down your pants and your panties.
Yeah.
Right? Who was at that board meeting?
Mr. Papale, Miss Stephanie Boudreau, Miss Charlotte Martin's assistant, my sister, and Julie Harris was over Skype. So I did this over Skype. Was that recorded? Like, I was in a board meeting room.
So there
Mr.
were...
Papale did leave the room. So I guess I was thankful for that. But to this day, I still don't know why I complied with that request. But in that moment, in those...
Who asked you to do it?
Julie Harris.
No. And so, okay, that's what I needed. All right, Senator Tarver.
No, that's the same question I was going to ask.
Okay, thank you. Senator Morrell?
Thank you so much for your testimony. I'm honestly speechless. I understand, and honestly, this is why when we were doing the confirmation hearing and everyone's glad handing about how few complaints they have, I'm trying not to use explicatives, how many people came into contact with Mr. Papale and never filed a damn complaint?
Mr. Veters.
Because I'm talking about the investigator. How many people came in contact with your investigator and never filed a damn complaint? Because based upon these 2 people's testimony, and mind you, they're under oath. If this is what they went through, how many people are being assaulted and being dismissed by your employee and aren't filing a damn complaint? So we have 30 on the books. But if a sexual assault victim is being met with disdain, if they're being encouraged not to reach out to advocates to advocate for them, I will be happy to provide all of you with a copy of Morgan's letter because it came to our board, our committee as a public record. But her job is to be a voice for sexual assault victims. For your investigator to question why she's there, A, is at least indirectly questioning the validity of their complaint, and B, is just plain damn offensive. I don't know what the hell's going on with your board.
Is Mr. Papale here?
No, ma'am. He's not.
Okay. Is there any reason he didn't come?
We weren't aware of what this was about. We, despite a request,
I'm sorry. What's your name?
My name is Courtney Newton. I'm
Okay.
their attorney.
Miss Newton.
Courtney Newton.
Okay. Did you filled out a card?
I did,
got
yes,
you.
ma'am.
Okay. Thank you so much, Senator Reiser, for a question quickly. Excuse me.
Just want to bring it back out what Senator Morrell said, that everyone that at the table is under oath.
Yes, sir.
So that is, so
Yes, sir.
you're very aware that you are under oath.
Yes, sir.
Thank you.
Okay. Can you tell me who Miss Harris is?
I am.
And there was a woman that was just mentioned. Did you said that you were the one that requested that she pull her pants and panties down?
I did not.
Why don't you go ahead and explain that?
I'm so sorry. I was in the investigative committee and that was brought to me. And like I said, everything was.
What do you mean that was brought? You have to be very specific.
I'm
here.
sorry. I was appointed to the investigative committee in this case with, and then I was on Skype. I was in Shreveport. I live in Shreveport. I wasn't
Okay.
able to come down to Lafayette. So when you form an investigative committee, there's one board member, one lawyer, and then maybe another administrative assistant. Charlotte Martin wasn't able to be there, so Stephanie Boudreaux was there.
Who is Stephanie Boudreaux?
Stephanie Boudreaux is
She is a staff member who works on all the investigations.
So Miss Boudreaux?
Yes, Ms. Boudreaux is a staff member. She's full-time staff, and she assists with the investigations. She has been nationally certified as an investigator as well, just as our board members and I have been.
Okay, thank you very much. Okay, Ms. Martin.
So I'm a board certified orthopedic specialist. I was an adjunct professor for the LSU Health Science Center for Shreveport as a physical therapy program, and I used to teach for the residency program in orthopedics for physical therapy. I am very aware of all the manual therapy treatments that were implemented in this case, and you know, when this was brought forward to us, they put me on the case due to my expertise. Now, when I asked Ms. Jennings, as a manual therapist, we have to have palpation and know exactly where exactly we are, musculoskeletal disorders, asymmetries. We have to know exactly what's going on. So my recommendation or my instruction to her was, would you mind showing me where he touched you? I did not ask her to pull her pants down. When she did that, I want to tell you, I was on Skype, and obviously I wasn't there to obviously avert that. But when in Skype, I verbally said, no, you don't have to do this. She was very adamant about doing it. And it was such a surprise to me. It really was. I would have never asked her to pull her pants down. When I asked to show the area where you are, usually show me here.
So what was the area?
The area is a pubic symphysis. I'm going to go back. Well, I guess we'll talk about that later if you want me to give you information about that.
No, I just want to make sure. I'm going to ask you again.
Yes.
You did not ask Miss Jennings to pull her pants or panties down.
No, ma'am.
At any point.
No, I told her.
Was there a court reporter, or was this recorded at all?
No, ma'am.
Okay. And who else was present?
Stephanie Boudreaux and George Papale and then Ms. Jennings.
Okay.
Yes.
All right. Thank you.
And I was over Skype. So again, I was via technology, and when this was going on, I definitely did ask her, can you show me the area of where he touched you? And then she's like, well, do you want me to pull your pants down? And I said, or pull my pants down. And I said, well, you don't have to do that.
Okay. I got you.
Okay.
I'm Jenny Hall. I'm Lori's sister.
Okay. And you were present at the time? Okay. And this was a physical therapy's board meeting where she was the investigator was asking questions about the incident that your sister alleged occurred.
Yes.
Right? And do you recall that someone asked her to remove any clothing?
Yes, because she asked her to show her where, to tell her where she was touched.
To show her or tell her?
Right first, and then she said, "Well, can you tell me specifically? Can you show me specifically? Can you point to where?" And then Lori started to point, and she was like, "Well, I need to know where that is," because she was just touching the side of her shorts.
Okay.
And she asked Mr. Papale to leave the room.
Okay. She asked, why did you ask Mr. Papale to leave the room?
She presented to say, I can remove my clothing down. And I said, you
So-
don't have to do that.
Yeah, so why did Mr. Papale leave?
Because she said she was adamant about removing her clothing. I
Then
said,
you
well,
should have stopped him. My sister was there for her upper back. Do you think he
Hold
needs
on
to
a second.
touch down
Hold
there?
on a second, ladies.
Yes,
Hold on a second. I think we're.
understand that. I understand it. It's
No,
I
let me.
understand.
No,
I'm sorry,
everybody
go ahead.
stop. Just answer the questions.
Yes.
Okay.
So when she wanted to remove her clothing, I said,
No, I'm not asking you that question anymore. Okay.
What's the question?
I don't know of anyone who goes to a meeting who wants to remove their clothing, first of all.
Okay.
And so you're just going to answer the question I ask you. And the question is, why would Mr. Papale leave if she was only going to point to the area? You help me with that. Because there's no reason for Mr. Papale to leave the room if she was merely pointing to an area where the alleged incident occurred, right?
Absolutely.
Right? So why did Mr. Papale leave? And why is Mr. Papale not here? Let's do the first one. Why did he leave the room?
He left the room because she was insistent about showing.
She was insistent. Be clear in your words.
Yes, ma'am. She was insistent about showing exactly where it was. She wanted to remove her clothing, and Dr. George Papale. Then we asked him to leave, and to show him that. And she was very confident about. And she said, I don't have any problem with this to show you. I don't have any problem. She kept saying that. And I was assuring her that's not, you don't have to do that. And then so she wanted to be exact. She wanted to be transparent about everything. She wanted to reveal exactly what happened. I commend her for doing that. And so George Papale did leave the room before, obviously, when that incident happened.
Senator Morrell.
A couple of things. Based upon how transparent, apparently, Miss Jennings was,
Yes,
based upon the information in front of you, and maybe the other individual should come up about this process, because I'll tell you, I'm an attorney. Many of us up here are. I have heard of due process. This is not due process.
I'm very happy to explain.
No,
that
ma'am.
process.
Answer your question when I give you a question.
I'm sorry.
Okay?
I thought you called me up. My apologies.
No, I said, let me explain to you. I was a public defender. Many people up here are former district attorneys. I see Pete in the back. I wanted Pete to stay because, listen, this is, as much as I give my own DA, Leon Canizero, a hard time about some things he does, at least he takes sexual assault seriously. Because I will tell you, from what I'm hearing right now, honestly, I don't know how in the hell you can have an investigatory team looking at complaints of this nature and obviously have zero training on dealing with sexual assault victims at all. That is evident. That is absolutely evident. The nature of your profession is that you touch people, correct?
Yes, sir.
So obviously, it's in the realm of possibility that you're going to get complaints of sexual assault or sexual harassment, correct?
Yes, sir.
Does your board, does your investigators, anyone get training on how to talk to or deal with sexual assault victims?
No, we don't, sir, and we should.
For the life of me, and I'm assuming this prepare guy still works for y'all, correct?
Yes, sir.
For the life of me, how you can have a victim who is willing to go through all this crap to get to a hearing date, and you let a guy sign a damn voluntary 9-month suspension. How in the heck does a board do that when he already, according to y'all, had a previous note in his file? Your job is not to make it easy for him to get out of this, is to protect the public. You guys came up here previously and said there was a note in his file.
Yes, sir.
And obviously you had a victim who was so dead set on trying to protect the public, no matter how you shape or describe the environment. She was willing to pull her pants down to get this guy off the street.
Yes, sir.
And this guy got a 9-month slap on the wrist. And by the way, he still has a license. It's just suspended, correct?
As of right now, yes, sir. There's an investigative process right now.
We will get to that in a second, because we have a second victim who obviously tried to also file a complaint, and you heard her testimony how that process went. And she has plenty of documentation of her interaction with your investigator, which is hostile to say the least. Your job, this is what I meant when I said earlier about what your job is. I have dealt with enough sexual assault victims and people even charged with sexual assault. Your investigator's job is not to discount the testimony of the person calling to make the complaint. It's to investigate. And what these people have gone through just to get to your board is beyond offensive.
Yes, sir.
I'm so frustrated because realize something. I have a tremendous amount of respect for physical therapists. I have friends personally that are physical therapists. And the reason why I'm up here conflicted, Mike and I were just talking about Mr. Waldbach, because we came before the public and we passed legislation to ungate physical therapists from doctors. Do you know how this makes the legislature look? Because their argument, as you might recall, the argument of the groups that did not want to give y'all that authority was that this would happen. That when people would come to y'all for a variety of complaints, you would not be appropriately trained and you weren't as professional as they are. We look like fools. So part of my frustration is not just what these women went through. You're making the entire legislature look like idiots. I would love to hear how their experience comports with your process. Please proceed.
Thank you for the opportunity to speak to you. As you said, most of you or some of you are attorneys, and the process of the board, unfortunately, once a complaint is received, we can't simply take away a license. If that was the case, then due process would be lost. So as was stated, we receive a complaint. The complaint is not just submitted on paper by the board, by a complainant, and can be submitted by any individual. It can be information received over the media. It can be information received by a board member and the complaint initiated by the board. The complaint can even come anonymously if there is independent verifiable information that we can investigate. If we get an anonymous complaint and it's just an allegation with no evidence to support it, we have no evidence to proceed with the investigation. The complaint committee is formed, and as was stated earlier, that is to preserve the hearing panel so that the hearing panel has no knowledge of anything that happened before they hear the evidence presented at trial. That is established in a case called Haygood that involved the dental board. You can't mix prosecutorial roles and adjudication. You have to keep that separate, which is why this process exists. The complaint committee includes Ms. Charlotte Martin because she knows the processes of the boards. It includes the expert, a physical therapist. It can include one or more experts, the physical therapist. It includes an attorney who in this case was George Papale. He is not the investigator. The people on the complaints committee who are the ones who do the investigation, sometimes assisted by advisory committee members. They investigate. They may have an informal meeting with the complainant to discuss, not the complainant, my apologies, with the respondent who is under investigation to discuss it informally with them. They may have a meeting with the complainant to discuss it with them. That is what occurred that you were discussing earlier, was a meeting not with the entire board because the board doesn't know anything about the investigation at this point. It is a meeting between the committee members investigating and the complainant. Once it gets to that phase, we're preparing for hearing, and it is the role of the attorney to discuss all issues of concern that may prevent a successful hearing. It is to prepare evidence and gather information so that he can prepare. I spoke with Mr. Papale. I have no dealings with prosecutions at this point. I'm strictly general counsel. But from my understanding, there was confusion on the process at this point. It was thought that it was the complainant versus Mr. Veters and not the board in the matter of Mr. Veters, the prosecution on behalf of the board, and the fact that the complainant serves as a witness to the proceedings. So the witness, because you need to have appropriate due process, cannot hear every detail of the investigation because that would impact the witness's testimony and impact due process. So at this point, we're gathering information. We're getting ready to go to hearing.
Can I pause a second? All right, so I find your interpretation of due process extremely interesting Because, and like I said, Mr. Pete Adams is back there, and I might call him up there in a second. I don't know, Pete. I'm considering it. Your due process in favor of a defendant seems more thorough than prosecutorial due process in a criminal proceeding. A prosecutor in a criminal proceeding freely communicates with a witness because the assumption is that a witness who is under oath on a stand is going to speak truthfully. It seems like you're saying that we don't tell the victims anything because it might impact how they testify. Is that your position?
That's not what I said. We don't keep them up to date on every detail of the investigation. This matter...
Don't keep them up to date on the basis...
I said every detail. This matter concluded...
How often do you communicate with someone?
I am not dealing with prosecutions at this point, so I can't discuss it with you. This matter concluded in 6 months from the point that we received the complaint. The investigation...
Which matter?
The one that...
The Jennings matter.
Miss Jennings.
Because there's two, so just want to make sure you just...
We cannot speak on the ones under investigation. Statutorily, we are prohibited, and we must maintain confidentiality on that matter. That's a legislative mandate.
Okay, number one. Let me ask you a real basic question. Miss Jennings testified under oath that she was prepared up to the hearing that she was expecting to have with Mr. Veers in front of the board. Mr. Papale made the determination to not have the hearing and to allow Ms. Veers to plea out, correct?
Yes, I would like to explain the reasoning behind that.
I would love to hear the reasoning behind that.
Okay, administrative law is different from prosecuting. When you prosecute, you have the attorney, you have a separate judge, you have many separate entities. Here, all functions are maintained by one entity, and case law has stated you must ensure separation of those functions. So that is why it is different. An issue is that board decisions can be heard on judicial review. Consent orders cannot. These issues are very hard to prosecute when you have one witness and one physical therapist. I was not privy to the evidence collected. I can only say, based on my experience with other matters, if you were to go to hearing, there is a chance that there would not be sufficient evidence to meet the burden of proof. If you sign the consent order, not only can it not be overturned on judicial review, the consent order becomes public record, which then builds a platform upon which any future complaints can utilize that document to get worse and worse or more strict.
How many complaints were pending against Mr. Veers when Miss Jennings' complaint was there?
I am not aware. You would have to ask.
Whenever Miss can you repeat the question?
When Miss Jennings' complaint was being processed, let's say before her hearing date, how many complaints were pending against Miss Veers, Mr. Veers?
Just hers.
Just hers. And as you stated seemingly very, very impressively that he had a mark on his record already. I guess my question becomes, I'm trying to decide who's worse in the situation. I feel like based upon a willingness of an individual who was wrongfully treated or assaulted in the situation and her willingness to go to the board, the ability of the board to make a decision was removed from them by Mr. Papale, who determined before the board could hear the information that Mr. Veers would instead sign a consent form. Correct?
That is done by all administrative boards.
I'm not asking you about Mr. Administrative boards. I'm asking you about this instance. Procedurally, because you seem to be well versed on procedure, I'll give you that. Procedurally, when Mr. Papale decided to do a consent form, the board was no longer allowed to participate in the matters.
No. If you allow me to explain the process, I'm happy to explain how it works. So once a consent order is signed, it's not approved by the board yet. The board then receives the consent order and reviews the consent order based on the information.
But at that point, the determination of whether to sign the consent does not include the testimony of the victim.
The consent order includes the admissions of the allegations. So I don't have it with me, but it includes
my question was very specific.
I'm sorry, I didn't understand it then.
Once you decide to pursue a consent form or consent order, does the victim have the opportunity to address the board?
No, because it's not, the victim is
Okay, Madam Chairwoman, can I treat this as a hostile witness?
No,
sorry.
you can't. Just hold on a
simply
second. Let her
trying to
talk.
give you
I think.
information.
Yeah, she let her explain the process, because I think, as I got it, the consent order is recommended by the investigator and the lawyer, Papale, right, Mr. Papale?
The committee.
The committee.
The
of,
committee
of
who-
3 people who are not trained in sexual assault training, right?
The
So
committee who has
the committee who is not one of them is trained in sexual assault issues. Is that correct?
As far as I know, there is no training.
That
in
is correct.
sexual
I
assault.
just duly noted. Then
I don't
it is
think-
presented as an admission, as you said. I'm just repeating what I already heard. You don't have
I
to
know,
reiterate.
I'm just trying to
and,
give you information. I'm sorry.
and you've given a lot.
Overzealous.
I think
I'm sorry.
you're not overzealous. You've given us a lot of information. I think we understand. And when that information is presented to the full board,
Mm-hmm.
Senator Morell's point is that the victim's information, the victim is not permitted to come before the full board makes a determination on the recommendation from the investigator and the committee. The victim does not weigh in at that point. Is that correct?
There's a reason, but yes.
Okay,
Can I
give
say
me the reason. Of course.
So if there's a clause in the consent order that says if the board for any reason feels that this is not an appropriate sanction based on the admissions,
Yes.
then the board, there is no penalty or they cannot be a complaint for lack of due process for the board to hear the hearing and all the evidence to preserve the hearing panel. So the board is preserved as a hearing panel. So by presenting the consent order without any testimony or evidence, should the board say this is unacceptable based on this information, and it has done that before, we want to have the hearing. Then at that point, you go for a full hearing, and there is testimony and presentation of evidence, and that hearing panel, who already read the statement of the consent order, which is typically the administrative complaint.
What would rise to the level to give the board members the indication that there's a need for a hearing? This is just a generic question.
It really depends on the board at the time.
Right.
It depends on the facts. And the only time I have seen it is where they did not feel the penalty was appropriate in light of the information in the consent order.
Right. And so if they didn't have additional information from the victims, what might cause them to go from the recommended consent decree to even recommending that there be a hearing? Help me with that.
Okay.
How would a board member, these 3 new members who are trying to get confirmed today, right? Why would they have any additional information to move from the recommendation? Why would they not just rely on what they might deem appropriate expertise from the committee members?
So the way any order of the board is set up is a findings of fact and conclusion of law.
Okay.
So the findings of fact are essentially all the allegations of the complainant that they have admitted to or that could be proven by evidence.
Okay.
So they are presented with all the allegations who at this point the person has admitted to. So any allegation of inappropriate touching, it is in there. I did this.
So has there ever been an instance where the board hasn't followed the recommendation of the committee?
Yes, there has.
How many times?
A
lot?
No. I don't feel comfortable answering that without
Okay.
a review. I'm sorry.
Yeah, no problem. Do you recall, Madam Chair?
I don't recall because I'm not involved in all the investigations.
Okay, but is this a unusual occurrence, or is it traditional that the recommendation of the committee is followed by the board?
Would you like to answer that, Charlotte?
But is it fair to say that
That's fair to say.
that they would typically follow the recommendation of the committee that has done the investigation?
I think that they look thoroughly at all aspects. They look through the facts, the violations, and then the discipline, and if it's appropriate.
Sure.
But since I have been working for the board, they have mostly found that it is appropriate, and they agree.
And
Right.
may I add to that, if you don't mind? They might accept the consent order with modifications. So they might say, you have been suspended for 6 months. I don't agree with that. The board will only accept it if it's 9 months. And at that point, it's kicked back to the complainant.
Did that happen
I mean,
in this
not the
instance?
complainant, the respondent.
In this instance, it did not, but that has happened since I've been with the board.
Okay. All right, Senator Reiser for a question.
Thank you, Madam Chair. I'll ask from the chair, Madam Chair, we could ask that y'all can provide us all the sexual harassment and charges been brought before all therapists or physical therapists, if you could do that. And
I'm sure she has that
could
information.
that be possible? Just so we'll know that this So we'll have a better picture. Now, Senator Morrell asked a question. He asked how many cases, and you said at the time there was only one pending on Mr. Peters. How many complaints has he had in all entirety?
So
How many has come forward that's been sexually molested that that we're aware of?
okay. So whenever I said one was pending, it was the one. Whenever we concluded Ms. Jennings' case, hers was the only case that was open. Since then, we have received 2 complaints.
Do you have any prior to that on him?
In 2012, we
And
received.
I'm talking about the whole time he's been a physical therapist. From the time he's been, how many complaints were on him?
There were no complaints unrelated to this. So, for example, for supervision or practice issues or anything like that, there have been no complaints unrelated to this topic.
Is with 2 daughters that I'm with the rest of this committee that one is way too many.
Yes.
That and to the point made earlier is on anything on this or DUI, to say someone most of the time is the first time they ever did it. Might be countless number of times that has transpired before then. Does he have any cases that or anything that's before the board now that's on anybody's filed anything?
Yes.
In addition to this one, he's got more now.
Yes.
How many more could you say
At this time, we have 2 open investigations
on the same one?
on Mr. Veters.
Okay, is it Veters?
Yes,
Okay,
Veters.
I
Yes.
said Peters. Correction, Veters.
That's okay.
Okay.
Yes.
Thank you, Madam Chair.
That was in 2000.
Thank you, Senator Reiser. When will the so Miss with respect to Miss Jennings' case, that one is closed in the board's opinion? It's closed as a result of a consent decree?
Yes.
Okay, and the consent decree being between Mr. Veters and the board?
Right.
Okay.
That's all processes is between the board and the licensee.
Oh, okay.
We're the only entity that has jurisdiction to impact a property right, which is the license of the board.
Okay, and is there any way to revisit a consent decree?
Once it's been approved by the board, once the vote has been in, then it's a public record and it's closed. It's reported to the National Practitioner Data Bank. It's reported on the board website and in the newsletter. And
Okay.
it's closed at that point.
The other 2 investigations that are pending that Senator Reiser just mentioned, how long will it take before those 2 investigations are resolved? Is there a time frame that you have?
May I speak to that?
Yeah, sure.
The board has other tools in its pocket that it uses sometimes. Some is an agreement to abstain, which is where we protect the public by mandating during the course of the investigation that the individual cannot practice physical therapy. I cannot speak, I'm not part of it, but it's possible that he will be prevented from practicing until these matters are concluded in full. Like I said, I'm not privy to that, but historically that is a tool we have utilized. It's not, you cannot take it to the court and get judicial review on it. It's a contract between the licensee and the board. And
When
so-
you keep saying you're not privy to it, what's your position again?
I'm general counsel. So we separate general counsel because I help the board in the decision-making process. I guide them and draft the orders, and we keep that separate from the prosecutorial role.
Okay.
And then a separate attorney is utilized as a hearing officer.
Okay. And how are you hired?
I'm by contract. I'm only utilized as needed.
Okay, and the board hires you?
The board has contracted with me, yes.
Do they do an RFP?
I'm not, I think you're going to have to speak to the RFP process for professional contracts.
Yeah. How do you all hire Miss Newton?
Miss Newton,
I was there before Charlotte.
yeah, she was contracted with the board before and on a multi-year contract. There has not been an RFP submitted for our legal counsel.
How were you originally hired? Did you respond to an RFP?
No, I went to the board. I was working under an attorney. I went to the board to speak, and they met with me and asked me to interview.
Okay, and then they gave you a contract?
Mm-hmm.
Okay. And the hearing officer? There's a hearing officer and also...
Hearing officer was publicized based on my recollection. Multiple applications were received, and I believe multiple contracts were issued so that we would have availability of multiple hearing officers should we need to move quickly to hearing.
So there was an RFP for that?
I don't know if it was officially called an RFP because I'm not 100% familiar with the process, but there was an advertisement placed.
Okay. And how about Mr. Papale? How was he hired?
He's been employed by the board for 20 plus years, so
Okay.
I don't know.
He's an employee?
No, I'm sorry, misspoke.
That's okay. He's an attorney who's contracted with the board. Speaking to the hearing officer,
I want to ask about Mr.
Oh,
Papale
okay.
right now. Is he a contract? You say he's a contract lawyer
He's contracted with the board, yes.
for 20 some years?
He has been with the board since 2001, I believe. I'd have to check with him.
Okay, so
to make
18
sure.
years or so, something like that. Is he so he's not an employee, he's a contract. Was there an RFP for his hire as well?
I'm not aware of that.
Okay.
I'm not aware.
Okay. Is it true that there are 30 sexual assault cases, or is it just investigations broadly?
So those are investigations broadly, and would you like me to respond to Senator Reiser's question about the sexual assault numbers?
Sure, that'd be great.
I have those as well. So in 2018, we had 2. In 2017, we had 2. In 2016, we had 2. In 2015, we had 1. In 2014, we had 2.
Okay.
So those are related.
Those are the
within
investigations.
No, those are so
Complaints.
of,
Yeah, make
for
the
example, yes, in 2018, of the 34 complaints received, 2 were related to sexual misconduct.
Okay, of all the complaints.
Of
And a
all the
complaint
complaints.
is defined as is just receiving a letter.
Of information.
Receipt
it
of
could
it.
be through written, oral, through the news. It's receipt of information, and it can be initiated by the board in its own receipt of information.
Okay, thank you. Senator Morrell.
Couple of points, because obviously I'm getting information as we go through this. Number one, would you be surprised to know that y'all have never revoked a single license over sexual assault allegations? Would you be? I'm just asking. Would you be surprised to know that in the entire history of your board, you've never revoked one license for sexual assault allegations?
I can't say I would be surprised or not because each complaint is specific to the facts presented of that complaint.
And I'll be happy to provide some facts just for the board and for the public as to what these complaints look like. Meet Samuel Foster. In 2012, he decided to do a vaginal exam on a 25-week pregnant woman who was having hip pain and falling. She complained to the board. He was subsequently admitted, placed on 3 years probation, currently practicing. Samuel Schmidt, 2002. Mr. Papale, all these are his. Signed a consent order stating he had an appropriate relationship with a patient by kissing her during treatment. He was put on probation. After which he had subsequent complaints, and only in 2005, 4 years later, did he voluntarily return his license, which still allows him to go practice in another state, possibly, because he wasn't revoked, but let's keep going. Okay. Another complaint, 2017. Work as a physical therapist in a nursing home setting. Kissing, touching breast, upper thigh, vaginal area of nursing home patient. After being repeatedly asked to stop, he admitted to his behavior. He currently has a 1-year probation. These are all public record from your own files. 2 other individuals who in 2006, 2007 were accused of being pedophiles, one of which is on probation, the other which is working apparently with special need kids now. So let's just be very clear. Your board has problems, has real significant problems. I think that at least we can see from our perspective as a third party looking in, the common thread right now, one common thread is Ms. Papale. I'll be very candid. I'm going to work with some amendments on the floor depending on what Mr. Moss wants to do with his bill. But I will tell you that this has risen to the level where I'm going to talk to Senator Pearson and see what else is appropriate. But I have really serious concerns that, and I will not speak to what board members know or don't know, but there is a pattern of behavior here by at least one person who seems to be the continuing thread in this, Mr. Papale, who's not here, that the idea that in a board, in a profession that has such intimate contact with people, where people put themselves in compromising positions so that you can perform and help them, the idea that people could do such horrific things, and apparently they all get probation because you don't revoke anybody. And honestly, as much as we complain about the dental board and the medical board, they revoke licenses left and right for things that are far less egregious than this. Your number one job as a board is to protect the public. That is your job. Not to protect your profession. That's secondary. Obviously, as attorneys, we expect the disciplinary board to take our job seriously, discipline offenders so the public has faith in attorneys. For what it's worth, I know Mr. Tarver's not here. Most people hate attorneys in Louisiana anyway. But we need people to have faith in a board that is going to take these situations seriously. I want to ask you one legal question, a simple question. Do you have to have a criminal conviction to revoke someone's license?
No, but you have to be able to prove it with evidence to get through the hearing.
Well, if you're passing consent orders and voluntary consent orders and probations left and right, you'll have to have a hearing for that.
Well, those are used as a way to protect the public when you don't necessarily have the evidence.
You have
that think
madam, with all due respect, and I mean that in the way that we typically mean with all due respect, Mr. Reiser. With all due respect, the public is here, the people making the complaints are here, and they don't feel like they're being protected.
Yeah, we got a lot of work to do.
I defer to you, Madam Chairwoman.
You can make one, then I got a few.
Okay, no, something was brought up about the public not knowing about the board. I think it would be very good for there to be a legislature that all boards have their licensees post where the public can get information on the licensees, whether in their place of business or in their intake docs. That's strictly a public protection thing. The board has a website. We are mandated by law to put notices on where you can complain about board business on the bottom of correspondence to licensees, but there's no mandate that I'm aware of that requires you to educate the public on where they can complain. So that was simply a positive thing that the legislature may be able to do.
Yeah, I think to the point that Senator Morrell was making most recently is the issue of the hearing, right? And so if you like the provision that says that being found guilty of unprofessional conduct of sexual assault is one of the disciplinary actions, right, which would subject someone to suspension or revocation. You're familiar with that, right?
Or limitation, yes.
Or limitation, right? Mm-hmm. So what you're saying, I think I heard you say, and clarify it if I'm not accurate, is that, you know, sometimes the evidence doesn't exist. We do consent decrees. That's what comes before the board. But in order to get to this, wouldn't you need a hearing in order to be found guilty, correct?
Oh, wait, I'm sorry. What is this?
This meaning 2420, disciplinary actions and revocation.
No, a formal adjudication can either be done through a consent order or through an actual hearing. Both are considered adjudications of the board.
Okay, so you could actually revoke through consent decree.
When Senator Morrell said a voluntary surrender of license, that is essentially a public record. That's a consent decree in a way that we get a licensee to give up their license and make it public.
And you've done
record.
that in the past.
Mm-hmm.
Okay, so that's an option. That's something in your toolbox. And quite frankly, let me tell you what I've heard today. What concerns me. First of all, I would ask that the committee permit us to hold this bill, House Bill 368 by Representative Moss. No, nothing personal, Representative Moss. We just have some work to do, as you can see. We are going to reconvene and reset your bill for May the 29th, which is 2 weeks from today. And during that time frame, I hope we can talk about a lot of things and convene somewhat of a working group to try to help you get your board in a position and the regulatory authority in a position to get what I would call due process for all involved, right? It's clear that to me, that your investigatory process right now is woefully insufficient when it comes to sexual assault victims. Would you agree with that?
I haven't served on those, so
okay, no need to respond. Do you think, how about I do it this way? Do you think that the training required today is adequate for you to aptly and fairly review sexual assault victims of the licensees?
After hearing the brave testimony from Ms. Jennings and Ms. Walker, I would say that we definitely should take a look at what we're doing.
So there's room for improvement. That's all I'm saying.
Yes,
there's room for
absolutely.
improvement. Okay, so that's that's the kind of thing that we're going to work on for the next 2 weeks, right?
Ma'am.
That's number one. So moving forward, you can have better tools and have the appropriate skill set in the room to not have incidents like Ms. Jennings, because that should never, ever happen again. It shouldn't have happened. and it definitely should never happen again. But we need to make sure in law that that situation doesn't ever occur. One would think that it just is against the common knowledge or reasonableness of people that are serving in some position. So to me, it's egregious and offensive. But it happened, and so we have to deal with that. There are other issues with respect to Mr. Papale. We are requesting that he be here on May the 29th for that hearing. He needs to be here and before that committee.
A couple of points. The first one is, as of currently, there are 2 additional complaints pending against Mr. Veters, correct?
Correct.
However, just from the article, which is public record, there are 9 people who have come forward to the district attorney saying they were sexually assaulted by a physical therapist. What prevents you from contacting the district attorney's office and working with them to find out who the other victims are?
I can speak to that. We have spoken to the district attorney's office. We've received a list, and we've asked them if they've spoken to each of the victims, informing them about the licensing board and encouraging them to file a complaint, and they have.
Okay, so what you're saying is you have 2 complaints, there are other ones possibly pending.
Possibly,
Pending.
yes.
Okay. Obviously, when Mr. Veters was under suspension, you had this news happen, and I understand you said that it's tricky to extend or do a summary suspension. I have dealt in the administrative law field previously, and it's very difficult, but I find it kind of incredulous that in a situation like this one, you don't think you could begin a summary proceeding based upon the information in front of you, which easily meets the criteria under the law for disciplinary actions. I don't see how, based upon what you're hearing, waiting is an option. I think right now the challenge you guys have as a board and as a profession, and I'm being deathly serious here, is that as it continues to be perpetuated that a person who's under 9 counts of sexual assault charges is under probation with the board, that's a problem.
He's suspended.
Sorry, he's suspended. He has a license to be a physical therapist in the state of Louisiana. Is that correct?
Yes, but that's what a summary suspension is as well.
Okay. I think sometimes I'm saying things. This is not a law school exam. And I appreciate your very law school answers. Let me speak to the physical therapist, because obviously your lawyer is not getting what I'm saying. People are reading the paper, and they are seeing that a guy who has 9 counts of sexual assault is under suspension for 9 months, 4 or 5 of which has passed, correct?
Correct.
How do you think prospective patients are going to look at that while a DA is pursuing 9 counts of sexual assault, the board that regulates him, which has a lower threshold to revoke a license, has chosen to suspend him?
I do hear what you're saying.
And
I think what you're saying is that the board could summarily suspend his license to expedite a hearing. So the board could hear the matter.
I think the board has a lot of options of that. You have at least Ms. Walker, who's here right here today, who has a pending complaint. There is no reason why you could not expedite her complaint, which thus far, I will tell you, and I didn't get a chance to address it, and I'm sorry, Ms. Walker, I want to say it now. The idea that Ms. Papale asked her for her damn mental health records, you don't have to be a trained sexual assault advocate like Morgan is to know that is crazy. That is crazy. To ask someone, to tell someone who's a victim who made their complaint before the paper article broke, to tell them they need to produce their mental health records to prove they're not seeking fame or fortune. By the way, fame or fortune for a sexual assault, that in itself is ridiculous.
So let me, should I jump in for just a second?
Go right ahead.
Who holds the investigator, Mr. Papale, accountable? Who does he answer to?
He answers to the board.
Okay, so the board talks directly to, the board members talk directly to Mr. Papale?
Yes.
If there's a complaint against Mr. Papale, who would decide whether or not he should stay on?
And that is definitely to consider in the future. We're going to have to.
Like how
the
soon in the
boards,
future?
Like very soon.
Like, what do you mean? Like 24 hours?
Like outside the door.
Like outside the
We
door?
have-
Yeah.
we have- we're-
Because what I heard is that he's been around for 18 years, and maybe, I'm sure he's done a lot of good things over that time frame, but he may be a little outdated with the things that are happening right now. Right. And certainly don't want to discriminate based on age. I just had a conversation about that earlier. Right.
Yeah.
We need seasoning around, but we need people who are also trained to adequately do the kind, in his role as a lawyer and an investigator, to do, they need to be trained. And so if there was no RFP, if he was just hired to do something, and it seems like he was pulled in to serve in a role that may not be perfectly fit for what is needed from the board right now. That is an immediate consideration that this board should deal with.
Yes, ma'am.
All right.
I am glad that we had two brave victims who came forward to bring light to their experience with this board. We empower boards to protect the public. I think that there's a concern here that we have to rebuild public confidence in this board. I look forward to working with y'all on how we're going to do that.
I'm Charlotte Martin. I'm the Executive Director of the Louisiana Physical Therapy Board. At the last meeting, I misspoke to the committee, and I want to clarify to you all. I do not have a list from the district attorney. The district attorney, Mr. Moore, cannot by law give names of survivors who come forward. Mr. Moore did agree to send correspondence on our behalf to the survivors who have come forward. I do have this correspondence available to the committee if you'd like to review it, but it is a letter letting them know that we exist, our purpose, and how to report. We've also reviewed many training options for the board. We're looking at immediate training options in the near future. We still do have open investigations right now, and we realize the importance of communicating with the individuals who have come forward to our board. And also, we need to understand the psychology of trauma and all that goes with that. So we are reviewing training right now, and we do plan to have that completed in the near future. And then also through orientation for our board members, our staff, and other representatives who work on investigations during orientation and for annual training opportunities. This is an incredibly important issue for this board. They take the concerns of this committee very seriously. And I want to let you know that we're here. We appreciate the opportunity to be here and answer your questions today. So thank you.
Thank you, Ms. Martin. Senator Walsworth, for a question. We have Mr. George Papale, who is present, and he would like to speak. Go ahead, Mr. Senator Walsworth.
I was just trying to listen to, and you talked about the training and orientation and annual. When is orientation, when is annual, and when is like next week?
Yes. So
can you sort of, I think there's a need for immediate training, not just annual and orientation.
And I agree with you.
Okay.
So whenever I was speaking of orientation, I was speaking of for new board members.
For new board members.
Yes, any new attorneys, new staff, anybody would need orientation as well as an annual ongoing training. I do have, there are 2 live opportunities that we have been in contact with one of the advocacy groups who said that there's one in Baton Rouge and New Orleans in June, and our board member who is on the investigation right now is in New Orleans. So we are trying to find other opportunities that are more immediate as well. We've read articles on this information as well, but we are definitely in agreement with you that moving forward quickly on the training is important. And we've been in contact as well with an organization that has been looking at customizing a training for us that would be focused on disclosure of survivors and how that disclosure occurs, as well as the psychological process of trauma so that we can understand, and then sensitivity and communication. And they said that they can customize it for us and we can work with them. So I have all of that information here if you'd like to see it, but I don't know how detailed you want to get.
What kind of fund balance do you have right now in the board? Does the board have, let's just say, in a roundabout, I mean, you don't have to give me an exact number, but your fund balance, how much money do you have in the bank?
On our operating?
Yeah, I mean, how much money do you have, does the board have in the bank? You don't have any money in the bank?
No, the board is financially
stable. Can you tell us how much money you have in the bank?
Yes, the board has, I'm trying to think because it's just the end of renewals, about $1 million in the bank.
Okay.
Approximately.
And how much is your annual expenses, give or take?
Approximately $600,000.
All right. So where I'm going with this tells me you got about $400,000 that you could use, and you can find somebody to do the training immediately.
Yes.
Okay. That's okay.
Yes.
Immediately, not in a few months. Please. I think it's very important that you do that immediately. Okay. Thank you.
Thank you, Senator Walsworth. Yeah, and I totally agree that you all should work and identify a professional that has the appropriate expertise to be able to quickly, considering what has occurred and the pending investigations, that you have someone that can complement your new legal counsel in you.
That has been something that we've pressed in meetings also, myself, because this has to happen now.
Right.
I understand that there is a history, but we also have to look forward with this
Of
board,
course.
and they have to move quickly. And that's from me because I'm sitting here with this bill.
Yeah,
and
thank
something
you.
has to be done. And as I told them, this is not over, because next year I'll be back amending something else on this. Because we're not going to be perfect coming off the start with this. The board isn't, but we plan on working through it, Madam.
Look, and Representative Moss, I can't tell you how much I appreciate your leadership on this and your just fluid being able to evolve with everything that we learned in a short period of time.
Yes, ma'am.
And you too, ladies, and the leadership that you've shown in the chair. So I would just encourage you, because I understand that the board has emergency powers and that it may be urgent. This could rise to the level of some urgency to be able to move forward quickly. And to Senator Walsworth's point, you have the resources available clearly,
They do.
and so there really should not be an excuse to quickly evaluate, different experts that can help you. There are no further questions. I want to permit, if you would permit, Mr. Papale to come to the table. Mr. Papale, and welcome, sir.
Madam Chair.
Yes, sir.
Thank you, and I appreciate this opportunity to be here and speak. And Senator Carter,
let me, before you get started, we are on House Bill 368, and I know there was some communications with our staff, but this is with respect to the Physical Therapy Board, and I just want to make sure we stay on message here.
With respect,
yes,
and
absolutely.
Yes, I do want to use this opportunity briefly to speak to the meeting last May 15th. Senator Carter, I'd be remiss if I didn't thank you for your honoring the military of this country, and to tell you that I had served this country as an officer in the United States Army, a year of which was in Vietnam. I heard about the activities in this committee on the 15th. Thank you, sir. Thank you, Madam Chair. In my estimation, the committee, in effect, ambushed this board that I have worked with for 16 years in a way that I believe undermines this board's ability to protect the public. And at the same time, I believe this committee, perhaps unwittingly, unlawfully interfered in an active investigation and a prosecution. At no time did this committee contact me or request that I be present.
Okay, so let me be clear about what we're doing right now.
All right.
When you asked if you needed to appear because of what had transpired, we told you no. We are talking right now about House Bill 368, which deals with the Physical Therapy Board, and it talks about to determine and collect at the time of new licensure renewal, core set of data elements. And if you want to talk about that, we can talk about that right now. But if you want to talk about something else that already transpired in this committee that's unrelated to this right here, then this is not the place for it. We are not doing.
Can I speak, Madam Chair?
You can speak to this.
How about an amendment to that bill?
If you have an amendment to this bill,
yes,
you are not a member of the committee. You would have to have one of us offer it.
All right, so I'm done.
No, but you can speak to what you would want to amend, and then a member can offer it for you. That is not a problem. So,
with all due respect, Madam Chair,
okay,
I have great affinity for this board, notwithstanding what happened to me on the 16th of May.
Okay.
Okay, I support the bill. Anything that would happen, help out my former client, I would wholeheartedly endorse.
Okay.
And my heart and spirit is still with them. I will take this opportunity then to say that what my remarks that I will have will be prepared in a letter detailed to this committee,
okay,
fully documented. I will send one to the Senate President,
sure,
and to the press. And I thank you for this opportunity.
And Senator Morrell, I would like to.
Thank you. Mr. Papale, if you would. Well, actually, you can go sit down, whatever you want to do. I find it very interesting today that at the very least this committee affords you the opportunity to come speak and to be present. And that the irony is that part of the reason why we had that meeting last week is because there were victims who wanted a hearing and were denied that ability to have one.
That is not true, Senator. And I will make that abundantly clear in my response.
I appreciate that. I appreciate your response. And I appreciate the fact that when you sign a consent agreement without a victim's consent and you do not allow them to go to a hearing, we gave you more today than you gave them. Have a nice day.
Thank you, Senator.